Hi, and welcome everyone to another live chat with the Center for Science and Environment. My name is Seher Aheja, and I'm a program officer with CSE's Climate Change Program. And we're here to talk to you today about a very big, pressing, new, and I think mostly positive issue. On Wednesday of this week, the International Court of Justice in The Hague in Netherlands issued its advisory opinion on the obligations of states or countries in respect of climate change. And it essentially ruled that states have an obligation to protect the environment from greenhouse gas emissions and act with due diligence and cooperation to fulfill this obligation. But to unpack the exact implications of such a ruling and understand what this means, we have with us two very prominent environmental law experts. I will quickly introduce them and we'll get right into it. So we have Arpita Kodiveri, who is an environmental law and justice scholar and assistant professor of political science at Vassar College. And we also have Aditi Shetye, I hope I'm saying your last name right, who is the lead of strategic litigation at World's Youth for Climate Justice and a researcher of public international law and environmental law. So welcome to both of you and thanks a lot for joining us. We're going to keep this brief but specific. So I'll just dive into my first question, which is for Aditi. So we know that the United Nations Framework Convention on Climate Change, or the UNFCCC, came out in 1992, the Kyoto Protocol in 1997, and the Paris Agreement in 2015. These are all landmark global climate treaties, which had many countries come together and basically agree that climate change is important and needs to be solved. So can you help us understand what makes this ruling or this advisory opinion different? And in a nutshell, what has this ICJ advisory opinion actually declared? I'll give the floor to you, Aditi.
Yes, thank you so much, Sir. Yeah, that's a very good question. Especially given like the fact that there is so much news. I think a lot of mainstream media has been covering it as well. To be very brief, I think what this just let's begin with what the UNFCCC does, or like where it fits the Kyoto, the Paris Agreement, all these landmark multilateral treaties. First, that they are multilateral. That means that states have to come together on a voluntary basis to negotiate, to talk them through, and with consensus, adopt certain interpret them. The adoption needs to be interpreted in a way that they materialize the obligations that are there within these treaties. And if you do look at the judgment very closely, in the app, like in the legal sources from where this judgment is stemming, there is one part which actually talks about the UNFCCC being like an umbrella convention, and how it has the basic principles and basic obligations. And then the Paris and the Kyoto are such treaties that then, were adopted to materialize those basic principles and obligations within the UNFCCC. So this is basically, in short, what these three do. Again, if you go back a little bit to the questions of the General Assembly that were asked to the court, and also if you look at the legal sources, again, going into the first part of the applicable law that the law court has said on question one and question two, you can see that the court very explicitly mentions that this is coming not only from these three treaties, but it comes as an entire corpus or entire body of international law. So this authoritative ruling, the ruling is coming from the entire corpus of all the law that already exists that is relevant to dealing with climate harm, climate damage, and generally the governance of the climate system. So this means that apart from the specialized climate treaties, there is the international human rights law. There is customary international law, and all the principles and the adopt and what is accepted and ratified, that is also considered. This also the law of the sea. It also
Mm.
mentions the Convention of Biological Diversity. It also mentions the convention, the Montreal Protocol, the Vienna Convention on the ozone layer, and the Montreal Protocol. Sorry, and the Desertification Convention. So basically, the entire corpus of um, environmental and climate governance is considered in this. And I think while there are scholars, there has been a lot of literature about how climate governance or climate impacts affect all these other various rights or all these other various aspects of law. There was, up till now, there was no authoritative court decision that actually connected these two. So what
Right.
was happening so far is that CBD, like the Biological Diversity Convention, Convention on Biological Diversity, the climate, the desertification, the Escazú Agreement, all of this, they were working in silos. They were not
Mm-hmm.
getting connected because of and this was causing to like issues of fragmentation of the law, of general even other general principles of international environmental law. So if you
Right.
look at it, even under CIL, it has very specifically named the principles that are connected to climate governance. So I think to just put it very shortly, this is like a umbrella judgment, so to say. Like the top court has said that this is how you need to interpret this. You
Mm.
cannot like interpret it any other way. And
Mm.
now that it's very clear. Earlier it was not, like, even though it was clear and there was debate among scholars on where and how, but like, when a court says it, it's like an authoritative interpretation of what it goes. Like, there is very little for there's very little room now left for states to um
Mm.
like m- shy away from their obligations that are mentioned in the
So,
in these climate governances, sorry,
so
in the climate governance.
right, I'll just come back in. Thank you. So you're essentially saying that this is a tying together of multiple existing laws and treaties, which is important. And it's also now, I guess, technically, it should be harder for states to shirk their obligations of responding to the climate crisis. Am I right in interpreting that? Okay, perfect. So thanks. And we'll just get to the second question for Arpita. So, CSE's position on, global climate action has always foregrounded the principle of equity, and CBDRRC, which is common but differentiated responsibilities, and kind of bearing in mind historical emissions and historical responsibility for the situation that we're in now. Can you tell us a little bit about the implications of this ICJ advisory opinion for developing countries like India, and or more broadly, the implications for the global south?
It's a really great question. And I think a challenging one, because I think while Aditi has rightly laid out that this not only provides an authoritative guiding tool for how to read these multiple international legal frameworks, it also doesn't necessarily shy away from the politics of like accountability and understanding where mitigation obligations lie and when and how does the idea of reparations get activated legally, right? And that's huge. So I want to first like preface my response with that. That's massive. Like I think people don't realize how massive it is. You need to realize that the idea of loss and damage was mentioned in 91, right? And now we finally found a legal foothold on the concept of reparations. So having said that, I think what I'm going to start with is look at the mitigation obligations and then go into the politics of accountability and opportunities that the judgment provides for particularly countries from the global south. I think when it comes to mitigation obligations, what's interesting is there is a repeated mention of holding countries who are historical emitters as being one of the reasons we're in this crisis, right? And that's, again, a pretty big achievement for an advisory opinion. But it's kind of like a bit of a delicate dance that the AO has also had to do, right? It can't fully implicate those countries, but at the same time, it does want to provide an opportunity to say, yes, those are the countries we're thinking about. Because what it also does is it looks at CBDR and it kind of reads it with the Paris Agreement, which says countries in different circumstances, right? So it says that the idea of developing and developed countries is not static. So that's up for negotiation at any time. So countries like India and China, when it comes to the mitigation obligations, where do they get situated? Do they hold on to the Kyoto Protocol categorizations? Or do they kind of get read into the Paris Agreement kind of non-static, movement-driven kind of concept? And there was actually a separate opinion by the vice president of the ICJ, where he actually mentions that it doesn't sufficiently delve into ideas of equity and CBDR, particularly because he says, and he uses the concept of a carbon budget, where he says that high emitting countries and historical emitters have already, used up their portion or the fair share of the carbon budget. So now, how do we then understand accountability in that context? So in some senses, I feel that the AO has given us a legal foothold to look at these multiple ways of approaching mitigation obligations, but it does kind of shy away a little bit when it comes to figuring out how to look at equity in the CBDR. But again, I think that the biggest achievement is the pathway to reparations. I think this is the first time that we have seen legal clarity on remedies for breach of state obligations. So it also attaches the failure to mitigate to the remedy of reparations, to the remedy of like cessation of harm, to the remedy of compensation. And we know, all of us have been in this field long enough to know how hard it's been to even get those terms, liability and compensation in. So I think it's going to be a watershed moment in terms of legal struggles for climate reparations. And for the Global South, I think that's a big win. And I think it also gives ample and we can go into this in more detail perhaps a little later, but it also provides very, very clear guidance on how NDCs, EIA, and domestic climate policy should look at mitigation ambition.
Excellent. Yeah. I do know that there is a section on the preparation of NDCs and the question of how much discretion states have. And that whole section also actually talks about linking it to the Paris Agreement's Article 4, which is the one that says that it needs to be grounded in CBDR and also keeping in mind the differing national context. So it is true that they want more ambition from everyone, is kind of the message, but it is also saying we're cognizant of the realities and the need for some semblance of differentiation. Perfect. Thank you. Thanks a lot. On to my second question for Aditi. So actually perfectly flowing from what Arpita ended on, this is being seen as a watershed moment. And it's being lauded as a landmark and a positive step forward for climate action. But because we like to look at things critically, I will have to ask you of, what do you think was amiss, or what do you think as someone, for those listening in also, I think, Aditi, if I'm not wrong, you've been closely involved in the process of getting this judgment come to life. So, from what you've been advocating for, what could have been done better in this AO?
To be very honest, considering it was the International Court of Justice, which is traditionally not known to be like super super progressive on certain things, especially that are like, of such very, I wouldn't say delicate, but it is of a political nature. Like climate change is a political issue. I think there was it exceeded my expectations, especially because the Inter-American Court, which is known to be a very progressive court, has gone to such a large extent, and like it has given a very good advisory opinion. on climate change, and it went to the extent of declaring that it's a human rights emergency, like a regional court, an international regional court of human rights saying it's an emergency. So that was one of it. Like in comparison to that, I think I would say that the ICJ went a little bit step further in comparison to in the Inter-American Court, where that court actually failed to, although the opinion was very good, they failed to give very specific mitigation targets and adaptation targets, and the very specific obligations under those concepts, and those how like states should operate, especially also within the regional context, which they should have. And I think because it's an advisory opinion, it would have been okay for the court to go to that extent. But the ICJ, in fact, really, as Arpita mentioned earlier, it went to very specific, to a very specific extent. They spoke about very explicitly not non-state actors. They mentioned fossil fuel phase out and reduction, which I again think highly politicized issue. Moreover, I would say there were judges unanimously said all of this. So this also means a lot. So in comparison to that, I would say that like the court exceeded expectations on many, many levels. Also, from my point of view, again, like to give a little bit context about why I'm saying this, is that I've been involved in this campaign for almost 6 years now, all the way since I was in university. And now, and most of the civil society or the youth leadership was at that time, we were all in university. And now, after almost half a decade, over half a decade of driving the initiative along with states, closely with states, which is again not a very youth leadership, and states are not like something that people see go together. When we started the campaign, it was like, what are you talking about? This is impossible. Look at what happened to Palau 10 years ago. But it went that went a different way right now because of what we are saying, and also because it is a transfer. It's like the process has transformed, the process of it itself has transformed it so much. It has made international law accessible to countries from the global south, and that is because of a civil society movement that went behind this. So I think I would rather want to acknowledge that, and
Yeah.
yeah, and mention that this like, as much as it is very easy, and as a lawyer also, it would be like going into the technicalities, and when it's getting implemented, it's going into the all the misses and the gaps, I think is like a normal thing to do. But I think it is also very important to mention like how, like why it is a watershed movement, and what led to making the ICJ so accessible to especially global south countries, especially countries that don't even have embassies in like they don't have embassies in Netherlands. Like these countries like Tuvalu, they came all the way and they made sure that they stood and spoke to the court. So it talks about the human element of law and how it actually is a real thing. And again, so I think that is something that you cannot, I don't think it's an understated thing, and I don't think people should miss that. And I think people should actually acknowledge the fact that how important it is, irrespective of the law, keeping the law aside. To be very,
Yeah.
very specific, sorry, just to complete, last point is that you asked me what were the gaps. What personally, I would say, from my point of view, the court, on a legal point, I think the court missed to talk very explicitly about self-determination, because it also came very, very strongly
Okay.
from the Pacific Island states and
Right.
what it means.
Yeah.
So even though they went to sea level rise and continuity of statehood, I think that they could have
Taken the
connected that
step.
explicitly,
Yeah.
and made that connection, which was so important for frontline communities as well. So I think I'll stop there in terms of
Perfect.
um,
Yeah, no, thank you. We rarely get opportunities in climate work to really just feel good about something, so I'll take it. Thank you. On to my last question for Arpita. We'll have to wrap up soon. just briefly, what do you envision as the way forward from this legal precedent for climate action? Like, what is the role that this kind of a legal watershed win is actually going to play for climate action, particularly for, global South communities and actors and countries? And after that, any last words, and we will have to wrap up soon. Sorry.
Yeah, I think that's such a great question. And I think Aditi has sort of captured a lot of that in her previous response, which is this ability for law to actually be a tool for transformative change. I think very often we think of litigation or any of these ideas of international law as being very alienating. I think here's an example which kind of brings to life that something like the ICJ is actually accessible. And I think that's huge. In terms of the future and how the AO gets operationalized, we have to wait and watch. But it's very, very specific and has such robust legal clarity that one can already like pave a roadmap. So I'm just going to quickly like throw in some ideas into three buckets that's kind of been simmering in my mind. So I think one is in the realm of negotiations because it's giving such clear interpretive guidance of the multiple treaties. I think for countries in the global south, that becomes a tool for them to use in their negotiating processes, right? No longer can they say that the global stock take cannot be read with the Kyoto Protocol. Now there's like immense amount of clarity on how that's going to happen. The second is climate legislations, and particularly domestic climate legislations. I think it provides ample amount of possibilities in terms of looking at ideas like due diligence, looking at how the EIA should look at climate as an essential aspect of it. We've seen some of that emerge in progressive climate litigation, but not with such kind of specificity again. So countries like India, if they were to bring a climate change act, they can draw a lot from the AO. And then the last bucket, I think, would be future litigation. I think particularly in the context of claims for climate reparations, I think we're going to see a lot of litigation happen. And word is out that there are already cases brewing before the courts in the
Wow.
UK in the next few weeks. So yeah.
In the next few
Watch out.
weeks. Wow.
Yeah.
Okay. Amazing. Amazing. I think that sums it up. I don't have any more questions, and we're just about on time, but I will, ask you guys if you have any final thoughts that you'd like to share. Please go ahead. And I just want to let everyone listening also know that it's 2 a.m. where Arpita is, and Aditi is still at The Hague. So she's joining us from the ground and point of action, and we really appreciate it. But yeah, any final thoughts, and then we will conclude.
Yeah, I just wanted to add one thing very specifically for like the Asian region, the South Asian region, or even the Southeast Asian region, is that the as Arpita mentioned, like it has given a really clear pathway in terms of interpreting these principles. Like the court has also gone to an extent of saying that okay, even if you don't have a regional framework, or like if like just like Latin America, if you don't have a regional human rights and climate sort of a framework within the region, and you have domestic laws also, like the international customary law principles or customary law and international environment law principles has strengthened and read they are portrayed, or they are interpreted in such a way that not being a state party also, I think that is very particularly like significant in the court's judgment or the order, saying that if you're not even as party to, let's say, any of these specialized not just climate convention, like climate governance conventions, but like other conventions, it is still like you still have obligation, because climate change affects human rights and other rights, other like right to life, basically, in a way that
Right.
you cannot shy away from this. Basically, it is now it is, and if you don't, as Arpita said, like state responsibility will attract, and that's huge. So I
Yeah.
think, yeah, I think that is something that South Asian countries generally and Southeast Asian countries can, take forward as well.
Great. Perfect. Thank you. Arpita, any final words?
No, I mean, I seldom say this, but sometimes reading legally heavy documents doesn't remind one of poetry, but this advisory opinion does. So
Wow.
please take time to just read it.
Okay.
And don't like get scared by the legalese of it. It actually talks about the politics, it talks about accountability and all of it. So yeah, just want to leave it with
Excellent.
that.
Yeah, thank you. Thank you both once again. The recording will be available. Congratulations, I guess. And here's hoping that more constructive use and operationalization of this AO comes through. All right.
Thank you so much.